Good evening and welcome to today's meeting of the Commonwealth Club of California, the place where you're in the know. You can find us online at commonwealthclub.org, on Facebook and Twitter, and on your YouTube channel. I am Judge Ladaris Cordell and your moderator for today's program. Our guest is Adam Benforado, Associate Professor of Law at Drexel University in Philadelphia. His work applies insights from the neuro or mind sciences to law and legal theory. In his new book, Unfair: The New Science of Criminal Justice, Professor Benforado combines his legal and psychological research to demonstrate that our system of criminal justice is fundamentally broken. He recently wrote a New York Times op-ed that, quote, "Our legal system is based on an inaccurate model of human behavior. Our studies suggest that implicit bias rather than explicit racism is behind many recent tragedies." He believes that behind every conviction of an innocent person, false testimony, or the denial of parole, there are unrecognized psychological biases which cause legal decisions to be anything but fair and impartial. Tackling this dysfunction and inequality head-on, Professor Benforado hopes that by uncovering this relationship between psychology and the legal system, we can implement reforms that account for human error and ensure truly fair justice for all. And he proposes practical and fascinating reforms that could prevent injustice and help us achieve true fairness and equality before the law. Professor Benforado studied history at Yale, graduated from Harvard Law School. We are delighted that his travels have brought him here to San Francisco and to the Commonwealth Club of California. Welcome.
So many thanks for that kind introduction. So I'm very excited to be here. And in the interest of full disclosure, there are really two reasons for that. One has to do with the wonderful food in San Francisco. I prepared myself for this talk by eating already. I've only been here like 22 hours, but I've already eaten burritos, sushi, and raspberry scones. Now, the more important reason why San Francisco is very special to me and why I was so excited when I found out that I would be coming here. And that's because this is a social justice city. Now, I don't mean by a social justice city that there is no injustice here. I mean that the people in this city know that it is not perfect and are striving for a higher plane, which is a view I am desperate as I travel around the country to encourage all across America. So what is this book about? The book is about the hidden forces that shape the behavior of detectives and judges and jurors and witnesses and experts and really all of the actors in our criminal justice system. And in each chapter, I look at a different character and I contrast the conventional stories that we tell about how these people make decisions and where things go wrong with what the latest evidence from psychology and neuroscience has to say. So in this talk, I just want to give you a taste. You can see there's a food theme here, a delicious taste of what's in the book. And so I'm going to focus on just 3 myths about the criminal justice system. The first myth is that all victims are equal in the eyes of the law. So any high-profile case, the prosecutor is going to say exactly that. Trayvon Martin, the prosecutor, came out and said, all victims are equal. Doesn't matter what the color of the skin the person has. It doesn't matter if they're rich or poor. So we're going to look at that one. Second, when an eyewitness identifies someone with certainty, that's a really good basis for a conviction. Some people are already laughing about that one. We will test it. The third myth is that judicial bias is subject to introspection and control. So essentially being an activist judge or an umpire judge, on the other hand, is simply a choice a judge makes. And we'll talk about that one perhaps later. So let's turn first to victims. And I actually want to move ourselves over to the East Coast, to Washington, D.C. So it was a cold night in a nice part of the city, northwest, and a man named Jerry put on his slippers, went to get something from the car. So he stepped out onto his stoop, and he saw a body right on the sidewalk. Now, it turned out that the person on the sidewalk was alive, but they were unable to speak. They were kind of trying to get up. They kept hitting their head down as they sort of turned onto their side. So Jerry actually had to go over, put his foot, his slipper, under the man's head, so he stopped banging it. Jerry's wife came out, called 911, and a few minutes later, the fire engine pulled around the corner. As soon as the firefighters got out, the man on the ground started to vomit. And one of the firefighters immediately said, I smell alcohol. This is just a drunk. So when the police arrived, they were told, well, this is an ETOH, shorthand for an alcoholic, nothing to worry about. So they kept to the periphery. When the EMTs arrived, the crew leader said, we came all this way just for a drunk? So they didn't really go through their normal protocols. They put him in the back, and instead of going to the closest hospital, as they were required to do, they went to the one that was a little bit closer to the home of the crew leader to run some errands. When at the hospital, when they arrived, well, they put the man in the hallway just to sleep it off. It was a busy night. Waking him up would cause problems. Sometimes when drunks were woken up, they got into fights, they were belligerent. So better to just let him sleep it off. Well, that's how things went until one of the nurses walked by and heard very strange breathing coming from this man. It was almost sort of a snarling sort of breath. And so she went up and she did a sternum rub, and his arms and legs flipped in, what's called posturing. Now, that is not a sign of drunkenness. That's a sign of a head injury. Doctor saw these events happening and rushed over immediately. They took this man to the resuscitation room. They called in the trauma team, but it was too late. He died. This was no drunk. In fact, this was David Rosenbaum, New York Times award-winning reporter, a luminary of Washington. He'd had dinner with his wife that night, gotten the hiccups, decided to walk around the block, search of a brisk air cure. And two guys had jumped him and hit him in the head with a bar, robbed him, got in a car, sped off. Now, why I focus on this case in the book is that I think it illustrates how when it comes to assessing victims, we often sum them up automatically and quickly based on what is directly in front of us. The color of their skin, their age, whether they appear to be wealthy or poor, even the smell on their breath. And these initial assumptions end up shaping the entire trajectory of a case. It can mean the difference between spending 20 years in prison and being free. It can be the difference, as it was in this case, between life and death. So one of the psychological demonstrations that I mention in the book involves two groups of students who were asked to draw a young man's face. So they were just given a photograph, and they were given a very simple task. Just draw what you see. Now, the only difference between the two groups is one group was told, along with being given the picture, well, he's a black guy. The other group was told he's a white guy. Well, that shouldn't matter at all. After all, you are looking at the picture as you are drawing. But it had a very large effect for certain people. And if you happen to have a copy of the book in your lap, you can turn to page. There's a little incentive to look at the book. On page 20, I have images from that study. Now, one of the things that's very damaging about labels is that once they're attached, once we've got that name tag on our chest, it's very, very hard to pull it off. So we saw that with David Rosenbaum. once he was labeled a drunk, all the other evidence in the case was filtered through that lens. There was a lot of other evidence that suggested this is not a problem. This is not an alcoholic. This is something else. The man's back pocket was ripped out. He had on his wedding ring and a fancy watch. This doesn't look like a homeless drunk if you're looking at it with the right set of eyes. And in fact, one of the very interesting things about this case is Jerry and his wife didn't think this was a homeless drunk. They thought this was a person from the neighborhood. In fact, they described him as looking like a distinguished, respectable person from the neighborhood. But by the time he got to the hospital and this label had been transferred, how did the responding physician describe him? Disheveled, like your typical alcoholic. That label is powerful stuff. So this is a major problem, not only for responding EMTs or police officers. It's actually a problem for our forensic examiners. So we tend to think about things like DNA, fingerprints, as the objective part of a case, doing that matching. But in fact, we've done laboratory research on this, and one of the things that we know is when that piece of evidence is passed to that lab technician with the additional information that this is from someone the police believe to be guilty because we have a confession or because we have an eyewitness identification, that influences the determination of that lab technician. And that's a very scary thing when the things we put the most faith in fail us. Blind testing has been a great benefit to the medical establishment, and I think it can be a great benefit to the legal system as well. Now let's now turn to our second myth, the one related to eyewitnesses. The idea that when an eyewitness stands up there in court and says, yes, that was the man who attacked me, that we can feel certain that we have the right guy. So for this story, I actually want us to move a little bit farther down the East Coast, down to Meriwether County, Georgia, 1979. There's been a brutal rape. Victim brought down to the local jail. And she's presented with 5 gentlemen. She looks at them, and she says, yep, number 3, that's him. Number 3 is John Jerome White. He's rail skinny. Standing, hand on his hip, white shirt, ripped blue jeans, shorts. John Jerome White goes to prison for something like 2 decades. Then they do the DNA test on the forensic evidence. He didn't do it. Now, I found a lot of cases that were like that. That's not what surprised me when I found this photograph. What surprised me was the actual perpetrator was in that original lineup. He'd just been locked up for an unrelated offense in the jail, just been pulled in as a filler. They needed someone else to stand next to the person they thought did it. So what does that mean? That means the victim looked at the person who had committed this atrocity against her, picked out the guy 2 people over. And you know what happened? That guy she missed, the real perpetrator, went out to attack another woman. There are serious consequences when we make errors. And more importantly, the key theme here is well-intentioned people, good people, with every incentive to get it right, can make terrible and lasting errors. Now, if we look at the statistics, out of the first 250 DNA exonerations in the United States, 190 of them involved mistaken identifications. Every year, despite this fact, tens of thousands of people are charged with crimes after being identified by an eyewitness. Yet we know from real-world data, 1/3 of the time, when an eyewitness is brought in, picks out one of those fillers, not the actual person that the police have their eyes on. So what's behind these problems? Well, first of all, our memories do not work like cameras, as we assume they do. Simply seeing something does not commit it to memory. And there are a lot of things that can negatively impact how we encode and then later recall a memory. A lot of these things are not in control of the criminal justice system. So it matters whether you're making a cross-racial identification. If you are a white person and you are identifying a black person, chances are you're going to be less accurate. It matters a lot. We might think it might matter a little. It matters a lot whether we see someone at dusk or at midday. It matters a lot if we've just been physically exerting ourselves during the period when we encoded that memory. Now, as I said, these are things that the authorities can't really control. But there's a whole bunch of stuff that police officers are doing right now that is causing misidentifications. And one of the reasons is we just don't treat memory like we treat other evidence. Like think about a blood-stained handkerchief for a second. Think about what the police do with that, how careful they are about sealing that up, preserving it, avoiding any adulteration, making sure that they carefully track the chain of custody for that bit of information. Well, I'm telling you, memory is just as malleable, just as easily corrupted as that blood-stained handkerchief. But we don't handle it with care. We don't do the things that we know could preserve it and could prevent the types of mistakes that we know are happening. Now, the third myth. The third myth relates to this idea that there are basically two kinds of judges in the United States: activists, umpires. If you are going up, nominated for the Supreme Court, every, judge now knows you say you are an umpire judge. But the research tells a very different story. That in fact, all judges carry many, many biases. Some of those relate to implicit racial biases, for example. Other ones relate to things that we've never even thought to consider. So one of my favorite experiments in the book comes from Israel. And these researchers decided to look at this question of, well, what determines whether someone gets parole or not? Now, I teach criminal law. I would have said before reading this study, well, the things that must matter the most are how severe a crime the person committed and how they did in prison. Did they reform? Did they apologize? Did they show remorse? Did they change the course of their life? Those were not the things that mattered. In fact, the thing that mattered the most, the time of day when you came before the judge. If you came first thing in the morning, that was a great time to come before the judge. You had a very high, in terms of the grand scheme of things, very high likelihood of being granted parole. If you came right before that first break in the day, that was the worst time to come before the judge. Now, in talking about judges, I just want to focus on one particular story. It's a Supreme Court case from a few years ago. And this case involved a police chase outside of Atlanta. So a car driven by 19-year-old Victor Harris goes by a speed trap. It's going 73 in a 55. Not that anyone in this room has ever done that. But rather than slow down, 19-year-old Victor presses the gas. So another officer joins this police chase after a few minutes, and he gets permission to pit the vehicle. So this officer, Timothy Scott, comes up, taps the back bumper. And he chooses to do it on a stretch of road when they are going very, very quickly. And on this particular stretch of road, there's a little bit of a gully on the side. So when he taps the back bumper, Victor Harris's car tumbles down the side of the road, flips over. Victor is paralyzed from the neck down. Now, Victor decides to sue Officer Harris under the Fourth Amendment, which prohibits unreasonable seizures. In the same way that the Constitution prohibits a police officer from shooting a shoplifter in the back as he runs out of the store with a pair of pants, Victor's argument was you can't use a potentially lethal pitting technique when all someone has done is a minor traffic violation. In this case, the officer knew that Victor wasn't out on any serious warrant for his arrest, knew that this was not a stolen vehicle, could have just gone to his house, picked him up later. So, in the lower court, Victor won on the grounds that Scott's actions were unreasonable. But in the Supreme Court, things went quite differently. Now, the interesting thing is that usually the Supreme Court defers to the lower court's determination when it comes to factual details. But in this case, there was a twist. There was a videotape of everything that had happened. There was a squad car camera. So Justice Scalia watched this and said, "This is the scariest chase I've ever seen since the French Connection." And the Supreme Court majority said, well, no reasonable juror could possibly watch this footage and believe that it was anything but extremely dangerous and that Victor was to blame for his own injury. Now, some law professors decided to check that out. Is it true that no reasonable juror could possibly see it differently than the Supreme Court majority? So they went out and tested a broad cross-section of Americans, people of all types. And what they found was distinct subgroups of citizens saw things very, very differently. Wealthy, white, conservative Westerners saw very different facts than poor, black, East Coast liberals. And the fact that our backgrounds and experiences shape our view of seemingly objective facts has actually been documented in a whole range of different contexts, different cases, and is commonly referred to as cultural cognition. But there's another reason that we need to be skeptical of the videotape's ability to offer a singular objective take on reality. And that's something that psychologists refer to as perspective bias. Now, the most commonly tested area for this is in interrogations. And the way these experiments usually work is they put a camera behind the interrogator, the detective, and they put a camera behind the suspect. Now, again, that shouldn't matter. It's the same events. They're just being taped from different perspectives. But in these experiments, what they find is it matters a lot what footage you're looking at. If you're looking at things over the shoulder of that prosecutor, you tend to see things from his perspective. It doesn't look like a coerced interrogation. But if we watch the events essentially through the eyes of the person being interrogated, suddenly we see all of these different pressures out there. And a lot more people say, wait a second, no, this is a coerced interrogation. It can't come in to trial. What this suggests is that recent moves to attach cameras in California and other areas to police officers ought to be adopted with caution. I think it's a very good idea to monitor how people behave. We have other psychological research that suggests that when people know they're being watched, that affects their behavior. But when we only offer a take on events from the perspective of police officers, I think the evidence suggests we are stacking the cards against the people who interact with the police, and that's a reason to worry. Much better is to offer a third-party perspective. When we're taping an interrogation, don't just show that one perspective, show both parties. That's a way to control this problem. Now, in each chapter of the book, I offer specific reforms like this that we can make right now to address the problems we face. But we also need to think about a much broader set of changes. Indeed, we might think about it as a revolution. We need evidence-based justice. Medicine was once in a similar position. The problem was that doctors were deciding based on their intuitions, based on anecdote. That changed, and we now deliver much better medicine because it's empirically grounded. Business is going through a similar push to be evidence-based. When there are billions of dollars at stake, people who run corporations now realize we can't go based on our intuitions. Our intuitions are often wrong. We're going to collect data and we're going to analyze it. Even sports has undergone this shift. Law hasn't, though. Why? I think with law, we tend to think that the people who came before us, who gave us our laws, are somehow more enlightened, more perfect than we are. I want to disabuse you of that notion. The law needs to change. It needs to keep up with the times in order to be just. Now, the thing I fear most, I think we are at a rare moment. When I wrote this book, started writing this book, I had no idea what was going to be happening right now in the United States. And I'm really excited because as I talk to people, and the book's only been out a week, but I'm getting emails from people all around the country, police officers, judges, people who have loved ones who are locked up. And I feel like this is a special moment in our history. I feel like it's special, and I'm seeing people actually reaching across the aisle. If any of you have been following some of these moves, for instance, to reduce the number of people in prison, there are conservatives and liberals joining forces to tackle this issue. And what I fear, though, is that our attention span is small. And there's going to be something on the horizon that comes up. Ebola might come sweeping back. And suddenly, all of those people who have felt the crooked nightstick of the law are going to be left in the lurch. So I'm counting on everyone in this room. This is a personal thing. I'm counting on you to care. And I'm counting on you to talk to other people you care about these issues. So I'm going to stop there because I know the judge has some awesome questions, probably very frightening because she's a judge, but some awesome questions for us. So thank you.
Thank you, Adam. So, Adam, this book is one of the most interesting and intriguing books about the legal system that I've ever read, and I really thank you for thinking about these issues and even more so for writing about them. So I do have lots of questions, as does our audience, so let's begin. So first, I thought that my knowledge of the legal system was pretty extensive until I read your book. And I learned that for centuries, we put animals on trial. So I'm talking about pigs, dogs, horses. Why and how did that inform the way we conduct trials today?
So this was something that I got interested in working with a cognitive psychologist at Penn named Jeff Goodwin. And he and I, he's Australian, and we gotten talking about shark attacks. And one of the things that interested us about shark attacks was whenever there's a shark attack, there are often people who come forward to go and track down the shark and kill the shark and get the shark. And we wondered, well, what is that about? Is that just about making the beach safer? Or is there something about maybe delivering payback to the shark somehow? And so we decided we got a grant from the National Science Foundation. And one of the things that was very interesting to us, Jeff's a moral psychologist, and we wanted to understand a little bit about, what really drives us to punish, right? We tend to think that we are very rational punishers, right? That's why we have solitary confinement. That's why we have supermax prisons. It's all about making things safer. That's why we have the death penalty. It's just to deter bad people. And so what we did was we started doing research, actually looking at people's intuitions when it comes to punishing animals. And one of the setups, we ran a whole bunch of experiments. One of the setups was actually using sharks. we describe a couple of scenarios in which, a shark kills either a little girl or kills, say, a 45-year-old pedophile or someone. And again, if people are only motivated by making the beach safer, they should feel equally about putting these sharks to death. That's not what we found. In fact, we asked people, how much pain should this shark experience in being killed? We offered basically the ability to give this shark a painkiller, right? Before, as part of its putting it down. And people wanted to give the shark that killed the pedophile a lot more painkiller because perhaps it didn't deserve payback as much as other people. So what this research suggests, we looked at a whole bunch of different kinds of people. We looked at actually people's intuitions about punishing adults. We looked at people's intuitions about punishing children. And one of the things we found was people don't punish necessarily for the reasons they think they punish. Retribution is a powerful drive. This basic urge for getting even. And I think that potentially explains not only these historical examples, and I'm not talking far, I talk about some things that happened hundreds of years ago, but I also talk about, dog trials in Kentucky in 1926. And one of the things here that I think is going on is it's retribution that's driving things. And retribution is a basic punishment motive that doesn't really distinguish between humans and adults, doesn't really distinguish between adults and children. One of the things that's really shocking, we have a system to treat children like children. Because on a rational level, we say, well, children aren't the same as adults. And yet, if you look at the data, we try so many kids in adult trials. Well, I think that has something to do with retribution.
Prosecutors get a good deal of attention in your book, and specifically you talk about prosecutorial misconduct, where prosecutors fail to disclose relevant information that the law requires them to reveal to the other side, to the defense attorney. And you write, most lawyers aren't consciously trying to cheat defendants. They're extremely good at deceiving themselves. What do you mean?
So I am a lawyer, so this is a little self-serving, but you're gonna have to stick with me. I looked at the research on dishonesty, and what I came away convinced by is that the reason that people cheat and act dishonestly is when it's very easy to justify their actions. So if you make it easier for people to rationalize, more people are going to cheat. Good people, bad people. Now, with the case of prosecutors, one of the things that I worry about is that our situations within our prosecutors' offices make it very easy for people to justify not handing over that evidence, exculpatory evidence, that shows the innocence of the defendant. In the laboratory, one of the things that's really interesting is people are actually more likely to act dishonestly when they're helping other people than when they're doing something for themselves. And if you think about the prosecutor who doesn't the blood test comes back, which doesn't match up with the suspect. So imagine a prosecutor who is convinced that this person did it. What are they going to do? Well, they may start to think, the police have already worked this case. They're good people. Maybe this blood sample doesn't match up, but maybe it's just a fluke. Maybe there's a problem with it. If I turn this over, this is going to confuse the jury. And then I'm going to be letting down the victim. Then I'm going to be letting down the public. If I put someone out there who's dangerous, I'm going to be letting down the public. I'm going to be letting down all of my colleagues who work so hard to keep up our conviction rates. I'm going to be letting down my family who's counting on me to move up the career ladder. And suddenly, not turning this over doesn't seem like such a big deal, especially in the context of the adversarial system. When the whole idea is we present our best evidence, the defense presents its best evidence. If the defense team does its job, this isn't going to matter at all.
So suddenly, this little thing, which looking at it just as, without the context, looks absolutely terrible. The prosecutors can start to rationalize. And the other thing that I worry about prosecutors is it's creative people who are actually more vulnerable to acting dishonestly. It's not intelligence that correlates with cheating. It's creativity. Because creative people are better able to rationalize. And the thing that worries me is, one of the things that I'm teaching my students is seeing every side of every issue. Being able to think of creative justifications for their client. And I think that makes them particularly vulnerable.
This is the Commonwealth Club of California program, and we're talking to Adam Benforado, Associate Professor of Law at Drexel University and author of a new book, Unfair, The New Science of Criminal Justice. I'm Judge Ladaris Cordell, your moderator, and you can hear the Commonwealth Club programs on the radio, catch up with us on Facebook and Twitter, and see program videos on our YouTube channel. So here's what you say about juries. One of the things you say: the best way to predict a jury's ultimate verdict is to look at what the majority of jurors favor before deliberating, because that aligns with the outcome 90% of the time. Really?
Yes, really.
And so I want you to respond to that and add to that. You talk about the biases of jurors, and you discuss body size bias. And if you could kind of put that in there as well.
Sure.
All right.
So taking the more general question about juries first. Now, one of the things that I mentioned in my talk was the fact that our backgrounds and experiences shape how we see the facts. So that suggests, right, that the people that we put on the jury probably matters to the outcome of trial. But it's not just the facts that end up mattering. Think about the law. Now, again, the way law has been taught in this country for decades is case books. You read case books, you deduce what the law is. When it comes to, say, rape law, right? When I teach rape law, my case book says it matters very, very much whether we are in a state that, say, recognizes a reasonable mistake in consent defense. That's going to determine the outcome, my casebook suggests. Well, other researchers looked at that exact context, date rape case. They varied the criminal law definitions, what the letter of the law said, had no impact on the verdicts. What mattered? Identities of the jurors, the mock jurors who were participating. Turns out, in this case, one of the key distinctions was actually between women. The researchers had started to think that, well, it's probably going to be men who view things one way and women who view things different. One of the big distinctions was between women. So conservative older women with more traditional gender norms tended to let the defendant off in this date rape case. Liberal young women tended to convict him. It wasn't the law that was doing the work. It was the identity. It was who you picked on your jury. Now, you asked this question about body image. One of the things we know is about outcomes here is that what people look like has a really big effect on how jurors view them. Witnesses who are more attractive, more likely to be believed. People who are heavier, going to fare worse. Now, it's not, again, that it's just a uniform effect, right? It matters what type of person is doing the judgment. It turns out men are a lot more body image conscious in this context than women are.
So following up on that, it comes as no surprise that race can be a factor in the whole punishment game. So you write in your book, it's not just whether you are black, it's how black you are. How black am I? What did you mean?
That is a great question. So in the book, I'm talking about the specific context of a death penalty case. Yet we know, if we look across the criminal justice system, African Americans receive higher bails. They're more likely to be involved in a case of police brutality. They're more likely, when it's a death penalty case, to get the death penalty. And the really interesting research looked at the facial features of African American people. What they found was people with more stereotypically African American features, thicker lips, wider nose, darker skin, those people were particularly likely to get the death penalty. Now, why would that be? Well, one of the myths I didn't talk about tonight, but that has obviously been in the news a lot, has to do with young African American men who have experienced over the last several months incredibly tragic treatment by the police. As you mentioned at the beginning, I think a lot of that has to do with what we call implicit racial bias, not explicit bigotry. So what is implicit racial bias? Well, the idea here is that all of us, I'm assuming most people in this room are Americans, have been exposed to powerful, pervasive stereotypes which link blackness as a category, and crime or violence. And particularly when we've got to make split-second decisions, we're influenced by that association. So think about the job of a police officer. It's very difficult. In writing this book, I actually went on ride-alongs in Philadelphia and in Brooklyn. And one of the things that I noticed about this was, first of all, there's a lot of time that's very boring, where you're just sitting doing paperwork. And then these moments in which you've got to make a split-second decision based on very, very little information. So what do people rely on in that? Well, automatic knowledge structures, these stereotypes, these automatic feelings that we have, that we may get from watching television. Think about it. I mean, I'm in Philadelphia. If you turn on the news in Philadelphia, 5 o'clock news, every night there's another story about a young black man and violence. That association gets stronger. And so when you see that black face, you're more likely to fire on him. We know we have shooter bias research, which shows in the laboratory where actually simulators, people are supposed to shoot or hold their fire. People make more mistakes when it's an unarmed black man than when it's an unarmed white man. The way these experiments work, oftentimes someone's pictured either holding a cell phone or holding a gun. When it's a cell phone and it's a white guy, that's stereotype congruent. When it's a black guy and a gun, that's stereotype congruent. Those are easy things to see. It's hard to recognize when it's a black guy and a cell phone, or a black guy holding his wallet. And that happens, right, with a police interaction. It happens when we get all the way down to that death penalty trial.
Well, before we start taking questions from the audience, I want to try to put you through a bit of a lightning round, if I could.
I'm scared by that, but I agree.
But
let's
give it a try. So at the end of the book, you suggest ways to improve our criminal justice system. And some of the reforms, quite frankly, I found to be startling. So I'm not one who's easily startled. So what I want to do is just throw out some issues in our criminal justice system. And if you could just kind of briefly give us an idea of what can be done, what the problem is and what can be done. So
Sure.
I'm just going to throw out, let's say 4, maybe
Sounds
5.
perfect.
All right, here we go. Peremptory challenges. If you could explain what it is and then
All
how
right.
we fix it.
So in the criminal justice system, we have this strange thing called voir dire, where before trial, we kind of sort through the jurors. And the whole idea of this was there are biased people out there, and we need to pick them out and make sure they don't end up on our jurors. So you can excuse a person for cause. Judge will kick someone off, right? If the person stands up and says, I'm married to the defendant, they're going to be dismissed. Now, we allow, in many cases, both sides, these special challenges in which they can dismiss people basically for any reason. Now, the Supreme Court has said you cannot kick someone off based on race. But in practice, what they allow to have happen is all you have to do to kick someone off is think of some other reason besides race. They were chewing gum. You know how they were kind of slouching in the seat? I don't think they're going to take this trial seriously. Did you notice how they had some trouble with English? This is a complex case, and I don't think they're up to the task. All of those reasons have been viewed as totally fine reasons. I think when it comes to peremptory challenges, we should just get rid of them. I honestly think that would be a better approach, because I think the way they are currently used is to bias the system, not to make it fair as was originally intended.
All right. Here's another one. Trial consultants. So my partner is a trial consultant, and I basically refer to her as a trial slut, because they're paid to... So anyway, what's your thinking on that?
So I want to first of all say that I think trial consultants and the lawyers who hire them, who many of my friends are lawyers and they use trial consultants regularly, are good, well-intentioned people. Now, I worry, though, deeply about the role of the trial consultant industry, because this was an industry that was started in the 70s with the best of intentions. These were social scientists who looked at some real abuse in our systems, right? One of the first cases was down in North Carolina, woman charged with killing a prison guard who she said raped her, and she said it's self-defense. Psychologists at Duke came forward and said, I want to help this woman ensure that she gets a fair jury in this case, right? And where she was going to have the trial was not a place where she could get a fair trial. So he brought his social science methods, ensured she'd get a fair trial. But look at what the industry has turned into. Now it's not a case of, let me see how I can remove bias. It's, pay me as much money as you can, and I will bias the system in your favor. And it's not just picking juries. It's preparing witnesses. It's practicing trial strategy. And the people who populate this industry, again, good people, are not actually a lot of lawyers. They're PhD psychologists, people who have this expert knowledge of the hidden forces that are shaping human behavior. And that worries me. And I think we need to, I don't have all the solutions about how we move forward, but I think we have to address this, or the widening inequality gap is just going to get broader and broader.
Suspect interrogations by the police and witness interviews.
So this is really, I think we need a sea change here. The leading way that we interrogate people in the United States is to bring them in. And the first thing we do is we decide if the person is lying. And the factors that we focus on are their demeanor, largely, right? Are they averting their gaze? Are they kind of jittery?
Sweating.
Are they sweating? So it turns out the things that we focus on are terrible ways to tell whether someone's lying. People who have done horrible things will look you straight in the eye. They will. Jittery limbs? If you have ever seen me go through customs at the airport, I don't know why, but I get nervous. And my hands get a little bit of shakiness. If I was ever called in to a police station, I would automatically move to the second part of this interrogation procedure. So as soon as the detective senses that this person is lying, they're supposed to move not to gathering more information. That's not the primary goal. The primary goal is get that admission of guilt. So what do? Classic good cop, bad cop approach, what's called maximization and minimization. And what we know from the research is when people are experiencing this very coercive experience, a lot of people tend to want to relieve that acute distress they are experiencing, particularly people who are young, who have mental health problems, may have low IQs. And so what they do, these people often, is they say to themselves, Well, if I confess now, I can relieve this horrible feeling that I'm experiencing. And I'm sure that when the police look into this a little bit more, my alibis will check out. Or the actual suspect, they'll find other evidence, other data will come to light, and they'll realize their mistake. But what happens in reality? As soon as someone has confessed, they stop looking for anyone else. All those other leads, they're not pursued anymore. And going back to one of the things I talked about at the beginning of the talk, forensic evidence, how we look at forensic evidence. Well, once you have a confession, that person looking at that blood stain, that person looking at that fingerprint, is more likely to find a match. And that's one of the reasons I think we've got to do something right now. European countries do a much better job. And one of the things, the big switches that they have made, is focusing on just collecting information. You don't need to force the person to admit they're lying. Have them talk. When people talk, they reveal things that you can use later to figure out the case. And it works a lot better than our current focus.
Criminal jury trials.
So, in the book, I focus on a lot of stuff that we could do right now. I think at police departments, prosecutors' offices, even on the bench. But there's some things that I look at far in the future, because I think we always have to have our sight not just on what we need to do now, but what we need to do in 50 years, 100 years. One of the things that I suggest that we ought to be thinking about is actually moving away from live, in-person trials to what I call virtual trials. Now that sounds weird. It does. But after reading this book, I mentioned so many biases that start with using our eyes. We don't need necessarily to see the color of a person's skin. We don't need to know how attractive they are. We don't need to see the gesticulations of the lawyer. All of these things make for great television. But I think they make for bad justice. And so I think we need to start to think about how we can control some of those factors. How we can control, for instance, when evidence is put before a jury. The current way we deal with that is that we then tell the jury, disregard that prejudicial evidence.
That's right. That
doesn't work very well. All right? Well, what if we actually taped everything with a delay? It would never have to go before the jury at all. This feels weird, and yet we do a lot of other very important things virtually now. We conduct international negotiations, very, very important business deals, even some medicine, right? A heart surgeon can now control instruments without being in the same room as a person. Why not start thinking about our criminal justice system? I think that's far in the future, but I think we need to be thinking about those seemingly outlandish ideas right now.
Wow. So let's take some audience questions. Here's one. How does the popularity of police criminal justice TV shows like Law and Order, etc., do they impact jury bias?
I think they do. I think that our television shows present caricatures of the way real lawyers, real defendants, and even real judges act and behave. And so then when jurors come into a courtroom, they expect to see the same stuff that they see elsewhere. And I think that's damaging. I mean, one of the examples that I would just point out is our expectations about lawyers. I mean, I don't like the depictions of lawyers because I feel like when you flip on television, they're kind of two kinds. There's like the bad lawyer, anyone who's seen, Liar, Liar, Jim Carrey's character, or many John Grisham movies and books. There's that evil, amoral shark lawyer. And then there's that, Clarence Darrow, just purely good lawyer. When you have that in mind, you're never going to address something like prosecutorial misconduct. Because you're going to be assuming that, well, most lawyers, right, if we give them ethical training, will be ethical, and then there'll be a few bad apples, and we'll round them up, and we'll throw the book at them. But that's not the cause, right? The cause is these environments we create. And so I'd like to see, in the prosecutor area, I'd like to see a switch from thinking about my goal as a prosecutor is to get convictions to my goal as a prosecutor is to deliver justice. All people who are guilty, I should ensure that they are convicted. And all people who are innocent must go free. And there are some examples of prosecutors' offices actually making changes along just this line. So the Dallas prosecutor's office has set up within the last few years a conviction integrity unit within the prosecutor's office, whose job is to double check, to look for when did we make a mistake. Why don't we do that everywhere? I mean, it seems so obvious, but we're not doing it. I think one of the reasons we're not doing it is TV.
What is your view about solitary confinement?
So, you probably saw this coming. I don't like solitary confinement. I think it should be rarely, if ever, used. And when it is used, I think it should be short in duration. We just had this, some people in the audience may be aware of this, just tragic case coming out of Rikers. Just happened. Young man. African-American man, arrested for a minor offense. Very minor offense.
I think it was theft of a backpack.
Theft of a backpack. And he is put into Rikers. He's a teenager, put into Rikers, where he experiences horrible brutality from both guards and other prisoners, ends up in solitary confinement. He kills himself. Now, the thing that's amazing about this particular case is he hadn't been tried and convicted. He was just awaiting. He couldn't make bail. When we are putting teenagers in solitary confinement, when we have the evidence that this hurts everyone, John McCain, Senator John McCain, he experienced solitary confinement, and he said this was the worst part. The physical torture that he experienced was not the worst part of his experience as a prisoner of war. It was the solitary confinement. If we have a man like that telling us this, why do we still have solitary confinement in this country? Other countries, like the UK, have radically reduced their solitary confinement populations. Some states are already moving that way. All states need to do that.
Are expert witnesses good for the system?
So I think they could be if they were used correctly. I think the problem with how we use them now is it's part of this adversarial approach that we've adopted in the United States, where each side, right, gets to hire an expert, and surprise, surprise, they tend to put forward evidence that aligns with what the side that hired them actually believes to be the truth. Some of you may not know this, but experts, it's not like the experts just suddenly called, come on this day to the trial and we'll ask you a bunch of questions. No, it's this entire process where they work with the lawyers to construct exactly what they're going to, the testimony that they're going to present and any sort of ways that they're going to deal with questioning at trial. I think a much better way to deal with experts would actually be to house experts within the formal judiciary system as an independent panel focused on delivering expertise. One of the things that's always struck me as very weird when it comes to something like the insanity defense is you bring in this PhD who's researched, right, serious mental health conditions that impair someone's volitional control, right? This person has spent decades studying this, is a foremost expert, brought in, presents his or her evidence related to the case, and then we say to the jury, well, you can disregard all of that if you want, you can adopt all of it if you want, it's up to you. You who have no expertise at all in mental health conditions, you who actually never even read a science book, got straight D's in your 8th grade science class, and it's up to you. I think that's a bad way. If we're going to have something called the insanity defense, shouldn't the people who actually understand mental health conditions help us there? I think they should.
All right, another question. What is your view of body-worn cameras for police? Should they be mandatory?
So it's interesting. So I talked a little bit about this previously. I think that we've got to be very cautious with, I think on net we can use them, but we probably shouldn't use them at trial. Right? So we shouldn't use, we can use them to gather data. I think it's probably going to have an impact on how officers behave themselves. But I don't think that we should offer it at trial as an objective take on what actually happened. I think the only types of camera footage that we should really rely on are ones where it shows the police officer and the suspect interacting, where we can see both parties for the reasons related to perspective bias that I've discussed.
Many judges have lifetime appointments. That's in the federal system. Mm-hmm. Do you think it's a good idea, considering mental faculties may decline or biases from another generation may influence their decision-making?
So the thing that worries me most about life appointments right now has to do with diversity. One of the things that we know is it's very hard to prevent people's backgrounds and experiences from influencing their decision-making. That's very difficult to control. So if we can't do much about that, one of the things that seems like a very logical solution is, well, at least let's have people with different backgrounds and experiences. If you look at the makeup of our federal judiciary, if you look at the makeup of our state Supreme Courts, it is largely white, older men. And that's problematic. And so when we have lifetime appointments, we're not getting the turnover which would allow the judiciary to look more like a cross-section of the United States. And compounding the problem here, obviously, is who has made the law? We have a common law system, right? Built up over centuries. Who was making the law over all of these centuries? Old white guys. That seems like a problem. And so to the extent that lifetime appointments don't allow our judiciaries to change and reflect what America looks like, I worry about that.
Can you give us one quick example of how you would reform, if you would, the prison system?
So I think there are little things that we could do right now. I think one of the big things is reducing the harshness of our criminal sentences. California has made some progress with changing their 3 strikes and you're out law, but there's so much more. We send people to prison for long sentences for crimes that wouldn't even send a person to prison at all in other countries. I think that's something that we need to change, in part because the research on deterrence suggests that increasing the harshness of sentences is a really bad way to actually deter people. If you want to effectively deter, the thing that's important is not how much you punish someone, but that you punish them, and that you do it proximately. So smaller punishments that are more certain are a better way to deter. And so one of the things that's actually, I think, would be a really good idea is to use that money to encourage more community policing. When people see police on the streets, that actually does change their behavior. And so I think that's something that we might do.
Wow. Well, Adam, our thanks to you, Adam Benforado, our Associate Professor of Law at Drexel University and author of Unfair, The New Science of Criminal Justice. We thank our audience here and on the radio, television, and the internet. I'm Judge Ladaris Cordell, and now this meeting of the Commonwealth Club of California, the place where you are in the know, is adjourned.